Kia ora, everyone. Welcome to this bioethics seminar. It's my pleasure to introduce Matthew Gillett, who of course is a friend of many of us here, and it's nice to see you again. Matthew's now at the University of Essex as a senior lecturer, but he's had a very interesting career before that, and has been involved with the ICC in The Hague, and at the moment has a particularly interesting project with the ARCC, which is titled Legal Human Rights, Cultural and Environmental Aspects of Founding a Biocultural Indigenous University in the Andean Amazon of Colombia. I suspect he might be drawing on some of the themes from that research in this talk. And I should also say that Matthew shares a surname with a very famous bioethicist. So over to you, Matthew.
All right, warm thanks and good morning. It's a pleasure to be here. It's a pleasure to see my namesake actually in the front row. So greetings from the other side of the world. And in terms of the interests that I'm going to discuss today, you're right that it does actually bring together some of my research interests, but also some of my practitioner work. And on the one hand, looking at the possibility of prosecuting crimes against the environment, which is still on the horizon of international criminal law. It's not something that has yet been done at the international level in any concerted way. Together with what has been done, which is this trial construct against typically leaders for large-scale organized crimes that we see at the International Criminal Court, for example. And so when we put the former into the framework of the latter, it presents some challenges. There are plenty from the practical perspective, but I think also before we even get to that stage, at the deeper theoretical level, there are some questions and what can boil down to some ethical questions before we make the final choices as to what format we want the specific crime to be and who should be charged for it. So with that by way of introduction, and with a warm thank you to the Bioethics Center for the invitation and to your interest in the topic, I will go through a presentation. I'll try and keep it reasonably brief so that there'll be a chance for a bit more of a discussion. And that way I can try and address your questions to the best of my ability. So what we see here is from back during the first Gulf War in 1991, when Saddam Hussein ordered the Iraqi forces to set on fire around 600 oil wells in Kuwait, which his forces had invaded, as something of an act of vengeance, but certainly something that had a massive ecological impact. And obviously at the time, you can see the huge plumes of noxious gases emitted from these fires, which could be seen as far away as apparently as the Himalayas. And so it gives you an extent of the geographic scope of the impact. And temporally, decades later, there are still areas in Kuwait where you can find this substance known as tarcrete, which is a sort of melding of oil and sand to form this hard substance that really suffocates the various forms of flora and cuts off food from the various forms of fauna in that area. So clearly, it's the type of example of massive environmental harm that we're thinking about when we're talking about ecocide. In terms of fitting that within the context of the International Criminal Court, there are some complementarities, and then there are some less congruous fits, which I'll go through. So firstly, on the positive side, let's say, the fact is the International Criminal Court is designed to be a safety net, a fallback mechanism that deals with cases that domestic systems are either unable or unwilling to do so themselves. That unfortunately happens reasonably frequently, particularly when you've got governments committing crimes against their own people, because obviously they will likely want to shield their own members of the armed forces, generals, and other personnel. So it's typically only when we have some kind of regime change that we see domestic trials being taken on by the country itself where the crimes occurred. We do sometimes see trials taken on by other states under this concept of universal jurisdiction, the idea that certain crimes are so harmful to humanity as a whole that any state should be able to try them, irrespective of whether it has a specific jurisdictional link, such as the link to the nationality of the perpetrator. And so we've seen that, for instance, with events in Syria, where trials have been held in Germany, in Sweden, in other countries, based on this concept of universal jurisdiction. So the International Criminal Court, though, does serve this function of a backup organization that is purpose-built to deal with these large-scale types of crimes. It also has quite a strong symbolic value. And even though it only can deal with a small number of trials realistically at any given time, having crimes listed under the court's Rome Statute sends a message that these are the worst acts known to mankind. And so when we see crimes against humanity, genocide, war crimes, now aggression listed, it of course suggests that if ecocide were added, it would be considered at that same level of gravity. So that has an important value in and of itself. And as I'll speak to in a few minutes, that could have a particularly important impact for corporations. Shareholders are not generally going to be eager on having money invested in an entity that's named as ecocidal in some way, or is involved in crimes that are listed on a parity with crimes against humanity, etc. Additionally, the International Court and international criminal law is quite well suited to addressing organized large-scale crimes. So when we investigate these cases, we always have organograms. We're used to dealing with various types of evidence like intercepted conversations, insider witnesses who can help explain the hierarchy and the structures behind the perpetrators. And when we think about environmental harm, the types of cases that reach that level of severity are usually not going to be one or two individuals. They're usually going to be organizational in nature, and it's often going to require that ability to patch together a perspective or a hierarchical understanding of how the orders were given, how the resources were provided, and why there was no accountability on the part of the organization, which is the type of analysis that the court in particular, but similar international courts, really specialize in. And then the question, of course, comes up, which crime? And this is where international criminal law in its current state has a lot of shortcomings when it comes to the environment. There is one crime, and you should see that listed here. This is the war crime in Article 8.2b4, which is applicable in international armed conflict. And that's the only point in the Rome Statute of the International Criminal Court in which the environment is mentioned. So it is the most specifically applicable crime. The problem with it, as mentioned, is it already only applies in one type of conflict, international, where you have a state on either side. And the issue with that is that the majority of conflicts in the modern world are non-international in nature, between often rebel forces and governments, or rebel forces and other rebel forces. We do have the glaring example of Russia-Ukraine at the moment, which is a classic international armed conflict from a legal perspective, but that has become more and more the minority and the exception in the latter part of the 20th and early part of the 21st century. So that's a major restriction for a start. Then when we delve into the actual elements of the crime, it gets even more difficult to apply, particularly when you think about proving each one of these elements beyond reasonable doubt. So firstly, you have to prove that the perpetrator has intentionally launched the attack. So it's not enough that they were doing something else and it led to a munition falling from the sky in the wrong place in a protected forest area or something. It has to be really intentionally launched. And they have to have the knowledge that the attack will cause. So again, it's quite a strong type of requirement. It's not may cause, it's not could possibly cause, but will cause. And then the two kickers, firstly, the conjunctive tripartite requirement of widespread, long-term, and severe damage to the natural environment. So it's not enough that one or two of those is fulfilled. All three have to be fulfilled. And that damage is clearly excessive in relation to the concrete and overall military advantage anticipated. And here, having worked as a prosecutor on several of these types of cases, it's my experience that the commanders will be aware of human losses and losses to infrastructure, but whether or not military commanders would be thinking about environmental impacts when they're launching attacks is questionable. And whether or not they would consider that the environmental harm is excessive in relation to the military advantage they're seeking and nonetheless go through with it is highly questionable. I think typically military commanders would think that the military advantage they were seeking was worthwhile and that it outweighed other interests, unless, of course, it involved hundreds or thousands of civilians being killed, in which case some would realize that is not proportionate and not justifiable. So that crime is a difficult one to establish, and probably for that reason, it hasn't yet been tested. We have an interesting example to throw it in recently of the attack, I think it was in June, on the Kakhovka Dam in Ukraine. And it, from most public reports, attribute this to Russian forces exploding some kind of munition inside the dam that led to large-scale flooding, some loss of life, but certainly huge environmental impact. I think over 100 human settlements were inundated, and large tracts of land and the various flora and fauna were harmed. I think there are some protected environmental sites in the area of the Dnieper River, which was where the Kakhovka Dam is located as well. So that's the type of case where you might start to look at applying this crime. But even there, a strong defense team could really push back on some of these elements. And a lot of these require a lot of interpretation. So aside from that one lex specialis or specific crime that refers to the environment, well, we have genocide. It's not impossible to think of genocide also involving or being conducted through environmental harm. There's the draining of the lands, the marshes of the Marsh Arabs in Iraq back in the 80s that we can think of, which was not found to be genocide in any particular case, but there are arguments made that because of it effectively erased the Marsh Arabs' way of life and it involved this changing of their ecosphere, that it could have been seen as a kind of combined form of genocide and some kind of ecocide. But again, it's untested. And the main point with genocide is the protected interest is groups of persons, national, racial, religious, or ethnic. Those are the protected groups. So the point of the crime is not to protect the environment, and any conviction you would get would be admonishing harming human groups, and any impact on the environment would really be just an incidental byproduct. Similarly, with crimes against humanity, that's designed to prohibit attacks on groups of persons, of human beings, committed on a large-scale or systematic basis. And so crimes like murder, forcible displacement, they potentially could be applied in conjunction with environmental harm, certainly displacement, persecution. We've seen cases of indigenous groups who've been hounded out of their lands through combinations usually of sort of burning off land, attacking, sometimes killing certain community leaders, imprisoning others who try to defend them. and extorting and taking their resources and money. So you could see it in combination, but again, the protected interest is human beings and human life. There are additional war crimes such as pillage and destroying enemy property. Again, they focus more on protecting human life or the property of humans. And so they can certainly be used to prosecute environmental harm, but they require conceiving of the environment as the property, which in some respects, the wilds, the global commons, places like Antarctica, etc., it's quite problematic to see them as property. And there are certainly contested issues and questions about putting that label on the natural environment. And then finally, aggression, which hasn't been used yet to prosecute at the international level, since Nuremberg, so over half a century ago. And again, there, the protected interest is anthropocentric in nature. It's human states, and it's not the natural environment that human states happen to occupy. So, in light of the limited range of crimes that could apply, when we look into international criminal justice, there's been this proposal for a definition of ecocide to be added to the Rome Statute. And here is one of the proposed definitions from this group, the Independent Expert Panel, the IEP, and you see the 12 of them there. They're well-known international figures from legal and political world. And so they've set out their definition as ecocide means the unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. They give some definitions of what those terms mean. Wanton is reckless disregard for the damage, which would be clearly excessive in relation to social and economic benefits anticipated. So you can already see some ethical balancing and assessments arising there. Severe is damage which is very serious, causes very serious adverse changes, disruption, or harm to any element of the environment. Widespread is beyond a limited geographic area or suffered by an entire ecosystem, species, or a large number of human beings. Long term, you see, which is irreversible or beyond a reasonable period of time, and then the environment. So that's the independent expert panel. In my book on this topic, Ecocide, last year, I propose a similar in some ways definition, but quite different in other ways, where I call it ecocide willfully committing any of the following acts and thereby causing severe damage to the natural environment that is also widespread or long-term. And then I actually list the specific types: killing, harming, removing protected flora or fauna, destroying ecosystems or habitats, natural heritage, dumping, trafficking hazardous substances, etc. And I elaborate on what willfulness is in some qualification provisions to provide an explanation. And then importantly, at subparagraph 2, you see that even if an act qualifies as under the main definition that I've put, it wouldn't be ecocide if it were strictly in accordance with international law, particularly international environmental law, and authorized by a competent national authority, so authorized at the domestic level as well. So it's conjunctive. So effectively, it would be really the defense proving that both of those were satisfied, in which case the action wouldn't be ecocide. So when you look at the two definitions together, my one has the enumerated list of underlying acts, so killing flora or fauna, habitat destruction, etc., versus the expert panel. If I go back, you'll see they don't actually list what the specific conduct is. So it's what I would call a chapeau definition. It's the hat without the specific underlying act, whereas mine list the underlying acts. And both of ours define some of the key terms, but that's a major difference. The second is my definition requires a result. So it actually requires you to actually thereby cause the harm to the environment. Whereas if we look back to the expert panel, they simply require that you have knowledge that there's a substantial likelihood that that damage could result. So they don't actually require any damage to result. Thirdly, it's more of a sort of technical legal distinction between wanton and willful. Both terms have slightly different connotations. And finally, what I mentioned about the escape valve, the lawfulness as an exception, and versus the expert panel has lawful, unlawful, or wanton, which implies even if it were lawful, otherwise, if your acts were wanton, that would amount to ecocide. So those distinctions are, from my perspective, important ones to debate, important to think about, particularly for the principle of legality, which requires that any act cannot be criminally punished unless it's reasonably predictable to a person. So it's written in some way and reasonably clearly, reasonably specifically. And it's a particularly important consideration when it comes to environmental harm, because there are plenty of actions, projects, undertakings that have quite valid reasons to go ahead, transport networks, even hospitals, which in Dunedin, of course, there's the hospital being developed at the moment. And many of these projects will have quite significant impact on the environment. So as a matter of fairness and lawfulness, it's important that persons engaging in those acts have a reasonable notice in order to plan their conduct and understand what is required and what is transgressive. So that brings me to this linked point of when it comes to the environment being a victim of actions by humans, how do we deal with that under international criminal justice? And here we see this slightly incongruous fit of the definition of a victim under Rule 85 of the Rules of Procedure and Evidence when attempted to be applied to the natural environment. So victims, firstly, under A, can mean natural persons who've suffered harm as a result of the commission of any crime. And B, may include organizations or institutions that have sustained direct harm, and it has to be properly dedicated to religion, education, art, science, charity, so sort of more public-humanitarian type purposes. The issue here is that under A, defining the environment as a natural person is not a natural fit. It's natural persons, if you see the way it's used in the Rome Statute, is clearly designed to refer to human beings in the sense of talks about the person's fair trial rights, etc., what happens to the person during proceedings. And there is some precedent for the environment being considered a legal person. In New Zealand, for instance, there have been examples. I believe the Waikato River was given a sort of form of legal personhood in proceedings. There have been cases in South America of similar attribution, but to call that assets of the environment or aspects natural persons is beyond precedent that I'm aware of, and certainly beyond anything in international criminal law. So then in terms of organizations or institutions, well, that's also difficult. I mean, these are anthropocentric creations, constructs, and to say that the environment is an organization or institution doesn't fit naturally again. So if we want to use this tool of international criminal law and all the potential that it carries and the influence that it can have to address harm to the environment, there are, to my mind, are three broad approaches. One, which I've alluded to, is anthropomorphizing the environment, so to conceive of it effectively as a human. And You, as mentioned, have seen examples in some domestic cases where the environment has been sort of called a person for legal purposes. So it's not without any precedent, but it does create these incongruities when you think about the environment and as a person. Does it mean the environment can be charged with responsibility for crimes if the environment destroys, if there's an earthquake that destroys human buildings? All these kind of strange impacts could arise, and so there are difficulties certainly from a legal perspective. There's also the risk of potentially muddying the message and undermining the force of the International Criminal Justice Project's message in relation to protecting humans. If suddenly humans, the term natural human or human being is expanded, then it can start to open the door to people who are against the International Criminal Justice Project, undermining it and suggesting that it's too vague, too fluid, and just doesn't make sense. So then there's the means of funneling environmental protections through representative claims by natural humans. And I put the example of environmental human rights defenders. There are many of these people around the world, often in areas with indigenous groups who they're protecting. I think Ken Sarawiro was one in Nigeria who was complaining vociferously about the harm from oil companies to the Niger Delta, if I remember right. There are cases that I deal with. I do human rights work for the UN frequently where environmental defenders are then put into arbitrary detention for years and hit with all kinds of charges and procedural complexities so that they effectively can't advocate and can't carry out their job of protecting the environment. So in a way, you could, by defending those people's human rights, and there is a right to a healthy natural environment, you could use them as conduits to achieve that broader environmental protection. The problem is if a tree falls in the woods and no one's around to see it, does it have moral force? And of course, this would mean that only in areas where humans could be tangibly linked to a specific facet of the environment would it really receive protection. And that in and of itself can cause difficulties. We're seeing it, for instance, in the context of climate change, because on the one hand, there's the tree in the woods if there's no specific human, whereas with CO2 emissions, what if it's all humans and potentially or huge amounts of humans are affected? Then courts often say, well, you don't have any special locus standi. What's your reason as opposed to anybody else to bring this claim? Usually to bring a claim, you have to be personally affected in some distinct way or reasonably distinct way. So that's a potential downside to the funneling approach. And then finally, there's the idea of reconceptualizing international criminal law using a protective principle. So the protective principle as an underlying idea that when we protect humans, for instance, crimes against humanity, it's typically in situations where a government or a government-like organization is involved, and therefore there's a level of protection that's required beyond that is normally required in day-to-day life, because they can't get naturally the protection of the usual legal structures that you'd look to. So that's why we justify international criminal law having this sort of exceptional applicability to cases that diverge or exceed normal domestic jurisdiction. And you could use that same kind of approach as a justification for protecting the environment. It can't protect itself, so in a kind of direct way. And so therefore, in the same manner, does that provide a justification for international criminal law to step in some cases to supersede domestic jurisdictional limits and allow these cases to be brought even where there's no specific harm to a human or human property? So these are three of the approaches, and they're not necessarily mutually exclusive. Certainly, the idea of funneling, I think, in the short term, has a lot of potential. There, for example, could be advocates for the environment, similarly to how we have the advocate for the child, who looks at in court proceedings the best interests of the child and does so independently of, typically in family court proceedings, the either parents' interests. And so you could see a similar role for whether they would have to be legally trained or not, I think is an open question, but certainly people with high-level environmental expertise, awareness, involvement, who could then come in and effectively present the interests of the environment. We have at the moment what are called victims representatives. So, for instance, in the cases from Uganda, you had victims who were family members of murdered people, family members of victims subject to sexual violence, and there was effectively, I think, one legal representative for that group of victims, and there was a separate one for the child soldiers who were sort of victims, but also at least physically perpetrators. And so they had a slightly different and in some ways conflictual type of interest, but nonetheless that needed to be upheld. So you could superimpose that same structure on advocates for the environment or environmental representatives who could then bring an independent voice to the court, to the judges and the prosecutors and defense lawyers who may not have that level of expertise, awareness, or necessarily inbuilt interest to look out for the interests of the environment. So those are some very initial thoughts, and I think with that, I will throw it open for discussion, unless I've talked you into a stunned silence. But I certainly welcome any questions or comments. Thanks.
Great, thank you, Matthew.
Thank you.
So we might start by seeing if there are any questions from the people who are on Zoom. But so if you come up with a question and you're on Zoom, just please raise your hand or just unmute and we'll notice that. Mike.
Great talk, thanks, Matthew. I'm just thinking, you mentioned global warming at one point, and that seems to be the greatest single, I suppose, overall driver of environmental problems. And you could say sort of ecocide, perhaps. That's a case where it looks like things like the burning of the oil wells in Kuwait would have contributed to it and various other ones. But no, these are all, it seems to me, contributory factors, and the outcome is probably overdetermined. And so everyone could say, my thing didn't actually cause it, it's all these other people or whatever. I just wonder how that, how that might fit into this ecocide. It looks like it's sort of, both of the definitions might have perhaps a bit of trouble picking out that. Well, I'd just be interested in your thoughts on whether that perhaps is a separate issue from the sorts of direct ecocide that seems to be in the headlights of these different definitions.
Yeah, sure. And that actually, you've hit the nail on the head, was one of the key sticking points in our negotiations or discussions to come up with these definitions. I should say I was sort of involved with the drafting committee for the independent expert panel, where they didn't use a lot of parts of our draft. And so, but during those negotiations we had this sort of 12 or 18-month period with a group of, some of us were international lawyers and environmental activists. And the climate change question was a difficult one. And so what I will do is show you in my definition, which you see, subprong F is focused on this, although it could actually fit under E as well. So each of these subprongs, I should say, piggybacks on an existing international environmental law conventional system. So A is to do with the Convention on Biological Diversity. and well, also the CITES Treaty on Trade in Endangered Species. And then when we get down to F, this is very much linked to the UN framework on combating climate change, the UNFCCC, and what we have as elements there are causing or contributing to. So it doesn't have to be the sole cause or the sine qua non, and large-scale emissions. Now, and also the flip side, destroying greenhouse gas sinks or reservoirs. So when you're cutting down large parts of forests that would otherwise absorb CO2. And some interpretation remains for judges if you were to adopt that definition. But in my book, I footnote reference to the UNFCCC so that the judges would at least have a sort of set of benchmarks that they could look to, and they could decide, okay, during those processes in Paris and elsewhere, this is what they've said is transgressive and is too much, and this is what they've said is normal industrial activity or commercial activity. So there'd be some kind of anchor. It nonetheless, I think, would be extremely difficult in two ways. One is the causation. So if you proving that a specific accused has contributed to the large-scale emissions would be difficult unless there were quite a discrete act. So I think that's where the setting of the oil wells on fire is a sort of locus classicus, in the sense of it's quite time-bound, it's a specific act. It doesn't just continue a trend, but it creates a major fork in the road as far as the environmental impact. So that's the kind of thing. Now, there have been a number of complaints submitted to the International Court, actually, about, for instance, Bolsonaro in Brazil. And there, it would be a trickier case because there was already rapid deforestation, for instance, going on in the Amazon. And it seems, according to these accusations, that his policies and approach sped that up. But if you try to disaggregate and prove what proportion, at least to sort of approximate proportion, he caused, I think it would be very difficult. And I certainly think you would need expert evidence. You'd also need the judges to be comfortable dealing with quite sweeping types of conclusions that are different from, for instance, when you're dealing with murders or even large-scale murders. You always have at least a few example murders, and then a bunch more have occurred, and it's kind of different discrete events versus the amount of CO2 in the atmosphere, which of course is there anyway. So yeah, I think that would be one of the really difficult issues. But personally, my view is that it is one of the most concerning areas in which humans are affecting the environment, so it couldn't be left out. Unless there were an additional crime that kind of had similarities, but that's lex specialis with that. But I think ultimately you're probably, from a political perspective, going to have more luck if you just you might get one shot. So you include it all in one amendment package and hope that that goes through. But yeah, thanks for the question.
Yes. Thank you. Yes, thank you for that lecture. Really, very, very interesting. I have a question, about constructing sort of a legal argument around, the corporate body argument, but also maybe more laterally, like a deodand argument, even though that's quite an old idea. Are you familiar with that, the deodand idea?
No, if you couldn't.
I think it was sort of a 19th century idea in England, I think particularly, where an object was given responsibility for an act of damage, and then would devolve to the crown. And it's Latin, but it's kind of attributing something to a sort of non-human object. But it seems more obvious is the corporate body argument where a corporation becomes a person in a certain way. I mean, can that be applied internationally in, you know, pursuit?
Yeah, it's a tough nut. Corporate liability at the international level, it's something that was already debated when the International Criminal Court was set up and was pushed back and ultimately rejected. But there has been one international court which has held corporations responsible, albeit it was for contempt of court. It wasn't the substantive crime itself, but there is this thin wedge, you could say, in the foothold in the door. So it's not completely unknown at the international level. The thing with corporate responsibility, I think there's a major upside, which is that sometimes these crimes are, especially in environmental harm, the accumulation of many small acts up the corporate scale, and there may actually not be one specific individual who has the mens rea to cover the entire criminality. In fact, they may, if the chief financial officer may be only looking at the financial impact and not really thinking about the environmental impact, if there is an environmental advisor, they may know nothing about what is actually being the scale, etc. They may just be giving some ex ante warnings. Oh, you should do this, this, and this. They might, but they might get outvoted, etc. The shareholders, of course, won't know probably in advance what the impact could be, because they will know very little about specific activities. And so what you can get is a lack of any criminal responsibility at the individual level, but an outcome that is objectively having a severe criminal level detrimental harm to the environment, and no accountability. And there's the famous quote by the judges at Nuremberg who were concerned about this, that crimes are committed by men, not abstract entities. And that's why they really wanted to hold individuals responsible. But in doing so, you can only do so if there is that level of mens rea to hold someone criminally responsible. And so that's where corporate liability has a lot of potential. The downside or the difficulty is that if you're going to have it for environmental harm as a crime, then it's going to beg the question, well, what about genocide? What about crimes against humanity? And I think states with the current momentum and movement and kind of their stated commitment to address the environment, I think there's some potential that they could accept it for environmental harm. I think they might be very reluctant when it came to other crimes, that they might just, or they might come under a lot of pressure when it comes to these other crimes. So that would be a difficult point. It's not necessarily exclusive to corporations. I do remember a case, I was in Afghanistan, and there was a shooting of I think it was Médecins Sans Frontières hospital in Kunduz, I think up in the north, and quite a few people got killed. When you broke it down and looked, though, that was amongst the military force from the US. You could see that the people in the helicopter gunship didn't necessarily know the details that the people on the ground knew. The people on the ground didn't have the same direct visual perspective as the people in the helicopter gunship. And the person actually ordering the attack had a different set of information again. And so from a criminal perspective, it would have been very difficult to actually pin anything on anyone, despite the upshot being several dozen deaths, I believe, and under a sustained, I think it was 12 or 15 minute kind of barrage from a helicopter gunship. So it was quite a serious failing and quite a really disastrous cause of death, but at the same time would have been very hard to prosecute. In terms of your point, which is an interesting one about the sort of responsibility vesting in the Crown as almost an insurer to provide remediation, that's where the human rights angle can come in quite useful, because in human rights law, it's the state that has obligations. So you don't have a state to your, you don't have an obligation to your fellow student. I mean, you're both private individuals. There's no responsibility on your part to uphold their human rights. So when people say, you know, to their friend, you're violating my human rights, it doesn't make sense from a legal perspective. But now that this right to a healthy environment has been recognized by the UN General Assembly, amongst others, and the Human Rights Council, the state or states of the world do have this responsibility to ensure that your rights are respected. And that's where you could have some very interesting constructs where you don't need to prove the criminal intent, but you can go and say, hey, you know, state X, you've given the permits to this corporation to do this mining or forestry project, etc. Did you carry out the proper due diligence? Did you X, Y, and Z? What about the people that are living in that area or rely on that area for their livelihoods? And so you could get the Crown in sort of New Zealand perspective, but the state in most perspectives as a responsible entity. The downside of that is that it might be seen as a bit of a get out of jail free on the part of some corporate actors, etc. If they are not ultimately held responsible, and well, the state pays, it almost could come across as sort of buying impunity for environmental harm. So in some ways, there's no silver bullet. And I should have at the outset said that Ecocide, from my perspective, despite having written a book on this, is not some panacea. It's not something that's going to stop environmental harm. But hopefully it could at least deter people in some cases. It could bring more awareness. And linked to this point about corporate responsibility, I do think it could have a major impact on shareholders. I think that could really chill a number of shareholders and get them to divest, or at least look to invest in corporations that can kind of confidently hang their hat and say we are adhering to best environmental practices. So there can be some positive coming from its symbolic effect. Thanks.
So I think there's a question at the back.
First question kind of on intent. So obviously with crime units, in the context of coming up with a definition for ecocide, there needs to be intent to cause that harm. And I think I was just sort of wondering, as you were sort of saying, often these things happen and they have significant harm to the environment, but that wasn't the goal at the outpost, right? Like targeting the dam wasn't about harming the environment, it's about cutting off water and making a statement or whatever from a military perspective. And so how do you go about coming up with a definition that incorporates sort of the role of intent exacerbating kind of the impact of the crime without ruling out crimes that don't necessarily have direct environmental intent but still have a significant environmental impact? Does that make sense?
Yeah, it's another good question, and another point that we debated, and this is going to continue to be a debate, absolutely, and for the actual cases, if they ever arise, this will be a major focus. So firstly, ecocide is something of a misnomer, or somewhat misleading, because it's based on the same origins as genocide, and for genocide, the essence is that specific intent. That's what makes it, in some words, the crime of crimes, because you are seeking to destroy the group in whole or in part. And whereas for ecocide, very rarely would anyone sort of just harbor such animosity towards the environment that they, I don't know, really want to kill a yellow-eyed penguin or something like this. It's not unimaginable, but much more of the time, and the much more serious harm is going to come from collateral effects, byproducts, negligence, that kind of approach, as you say. So when we construct the definition, I'll share the slide on this. So in my definition, I use the term willfulness. So if I go back one, you'll see how it comes in. Willfully committing. So what does willfulness mean? It's direct intent. So if you did have that purpose, or it was virtually certain that the environmental harm would arise, that's direct intent. as well as what we would call indirect intent, where you voluntarily assume the risk of the harm. And then it continues to say, however, a person who genuinely takes the appropriate and available measures designed to avoid the environmental harm is not willfully accepting that risk. So, let's say that you've got some kind of, I don't know, chemical treatment plant, and you follow all the guidelines, you have the proper tanks, but unfortunately there's an earthquake or something that unprecedented and results in this leakage of very toxic chemicals, and that does cause environmental harm. That's not the kind of intent we're looking for. And whereas cases which would be much more on the borderline, potentially included, would be the sort of Deepwater Horizon oil spill, where you have a history of warnings, a history of shortcomings in the various environmental protections being taken, and the prosecution can build up a case that warnings were given, they weren't responded to, or if they were, only in the most minimal way possible, and it made the occurrence of the environmental harm effectively much more likely than it would otherwise have been. So that is one way of formulating the intent. I should also, on this note, because it's quite a controversial one, is for the independent expert panel, they've come up with a definition of intent, which is wantonness. So it's quite interesting, and I think if this is adopted, there'll be certainly some debate. So as mentioned, they say unlawful or wanton. So let's put aside unlawful. Let's say it's wanton. Okay, what do they mean by wanton? Well, what they mean is reckless disregard for damage which would be clearly excessive in relation to the social and economic benefits anticipated. So reckless disregard is a term known to law, so that there is some basis which to understand it with. It's the second bit. It's the clearly excessive in relation to the social and economic benefits anticipated, which it somewhat mixes two things. It mixes your mental element relating to the likelihood of the kind of harm eventuating versus your awareness or your appreciation of how qualitatively excessive that harm would be in relation to social and economic benefits. So in my mind, there's actually two aspects to it. And I think for judges, and certainly having worked with and dealt with international judges quite a lot, they will hesitate at this point because an international criminal law judge, and even a domestic criminal law judge, is going to struggle with deciding what would be clearly excessive in relation to social and economic benefits. That's a very, let's say, contested type of question. That's a very contextually dependent type of question. What I think is going to be acceptable in one state might be completely unacceptable in another, and that might change depending on who's in government. If the Greens are in government, that's going to indicate that there's a strong perspective that's much more ecologically minded and less accepting of harm than in a country where they're not at all. And then you might get questions of equal application of the law. I mean, for genocide in New Zealand is judged by the same standard that a genocide in Sudan is judged, whereas this provision of ecocide could actually introduce some variability. I actually think that there is a legal argument to justify some variation, which is that there's an international environmental law principle of common but differentiated responsibilities, and that holds that developed states should have a higher burden in terms of engaging in, if they are going to engage in environmental harmful acts, it should be more restrictive, the scope for them to do so, because they've already had that opportunity to develop, than necessarily less developed states with less economic resources who should also be less encumbered by, let's say, the costs of environmental harm. And there's an idea that developed states should financially, but also technologically contribute to underdeveloped states to sort of level out the playing field in this respect. So I think if you went through that legal prism, you could justify a bit of difference depending on who was carrying out the act. You'd have to be very careful, because you wouldn't want a multinational corporation saying, oh, but we're acting in I don't know, Botswana, therefore we should be judged to a more flexible standard than if we were acting in Switzerland, for example. So you'd have to be quite careful with it, but there is a basis in developed environmental law to have some distinction. And again, it's important for me in my definition, and I think also for the expert panel, that all of these international law facets are interpreted coherently with each other. So in light of international environmental law, so you don't get something being totally unacceptable in one field, but completely acceptable in the other, and send that sort of mixed message. But yeah, mens rea in any criminal case is fraught, and particularly in an environmental case.
Thanks, Matthew. I was wondering, the term environment is quite broad, and I started to wonder only about 5 minutes ago whether we could call it the planet, because it's like an entity in itself, and it's something we all have in common with other people around the world. We are guardians, we are kaitiaki of the planet that we live in, and it could even extend once we travel to the other planets maybe and live there. This planetary law might be even more important, that we identify the planet as a unique place in itself, and the environment could come under that, obviously. But yeah, I wondered about the planet as an idea that could bind us more meaningfully to protect it.
Mm-hmm. It's another great question, because it's another point that was subject to discussions when we were formulating these definitions. And so what I can show you is the way that the expert panel has defined the environment. So you'll see it here in E. They define it as the Earth, its biosphere, cryosphere, lithosphere, hydrosphere, and atmosphere, as well as outer space. So it's pretty all-encompassing. I piggyback on a definition that's slightly more restrictive of the International Law Commission, that talks about, let me just find it, the natural environment should be taken broadly to cover the environment of the human race and where the human race develops, as well as areas the preservation of which is of fundamental importance in protecting the environment. This covers the seas, the atmosphere, climate, forests, and other plant cover, fauna, flora, and other biological elements. So mine is a little bit more linked to planet Earth. The expert panels is broader, encompassing outer space. And, I actually researched and wrote my book a few years ago, but now with Elon Musk and SpaceX and Richard Branson and these corporations becoming involved in outer space, there's an increasingly strong argument to say that we need to take care of that further afield aspect of existence, because, for example, space debris can increase exponentially. If one piece disintegrates into multiple pieces and they're flying around at the speed of bullets, they can then further hit into other space objects and cause more space debris. And there's talk of this, I think it's called the Kessler effect, where it could become so dangerous for humans to access outer space because of this kind of web of flying space debris, that we might actually cut off future generations from that opportunity, and that potentially may become very important in the future, that we're able to escape planet Earth. Who knows? So I think there's actually quite a good argument to say that the expert panel's definition of the natural environment is quite a good and a strong one. What you've said about the protective principle resonates with me, that it should be hinged to our responsibility to protect our home where we live. And it's just a question to me now that we're starting to increasingly not inhabit, but certainly be present in outer space as well. So maybe the house is growing, and therefore our definitions have to grow with that at the same time.
So thank you, Matthew. It's 11 o'clock, and I'm conscious that it's quite late on Sunday evening for you. So I think we might stop the recording now. But I know there were another couple of questions. So if anyone, well, you're free to run away now. But I know there were a couple of people. If you were able to stay on for a little bit.
No problem. And thanks. Great question so far. So I'm happy to stay for a few more minutes. It's 11 p.m. here in the UK. And so no problem at all.
Thank you very much.
Thank you.